Hello, I'm Richard Frase, professor of law at the University of Minnesota Law School. Here to talk about my new book, Paying for the Past, about criminal history prior record sentencing enhancements. I've been studying sentencing guidelines for as long as there have been sentencing guidelines. The first ones were implemented in Minnesota in 1980. And that was shortly after I arrived in Minnesota, and I've been studying them ever since. But I've studied guidelines in other American jurisdictions. There are federal guidelines, the District of Columbia has guidelines, and there are 17 states that have some kind of guideline system. 2 of them don't have commissions anymore. So I became interested in guidelines, and then with this particular aspect of guidelines, because it's one of the 2 factors that determines a recommended sentence under a guideline system. The other one is the seriousness of the offense that the offender is being sentenced for. It struck me that, one, there were a lot of differences between the guideline systems in the way they used criminal history, the weight they gave it, how they counted it, and secondly, that it was such a major factor, in some cases a more important factor in determining the sentence than the crime the person is being convicted, being sentenced for. These prior record enhancements have a major disparate impact on non-white offenders, particularly African American and Native American offenders. It's a major contributor to the disproportionality of prison populations, that there are many more African Americans and Native Americans in prisons than you would expect, including in Minnesota, than you would expect given how many of them live in the state. Julian Roberts is a professor of criminology, so I'm a lawyer by training. He's a criminologist by training, so we complement each other that way. I was thinking, well, who would I like to help me on this? There was really only one person to call. I mean, he's the expert, the world expert on criminal history. They need to be more clear than they have been about what their rationale is for these enhancements. If you're going to tack on years in prison, you owe it to the offenders and their families to tell them why you're doing it, and then analyze those reasons and make sure they're good reasons, and make sure that the enhancements don't exceed what can be justified under those rationales. And I certainly would urge them, if they're looking at retribution, at the idea that repeat offenders are more culpable, to consider very carefully what the philosophers of this, the people who spend all their time arguing about this rationale and trying to make logical, philosophical, consistent arguments about these principles. Pay attention to what they're saying, because you'd find out that some of them think it's all wrong. He's paid for his prior convictions. You can't punish him for them again. There's nothing about a burglar with a prior conviction that makes him more culpable than a burglar without a prior conviction. The burglary is the crime. The burglary is what you blame him for. Everything you think you know about prior record and sentencing is probably wrong.